Welcome to Nasdaq Trade Talks. I'm Jill Malandrino, Global Markets Reporter at Nasdaq. Joining me is Jim Bacchus, founding member and former chairman of the Appellate Body of the World Trade Organization, to discuss the WTO's role in global trade and the national security exception, a couple of new rulings out there. Jim, it's great to have you with us. Thanks so much for joining us on Trade Talks.
It's always a pleasure, Jill. Looking forward to it.
And besides COVID-19, headlines in the business cycle have largely been around trade, including the World Trade Organization. Give us a little bit of background here. What is it designed to do?
The WTO, the World Trade Organization, based in Geneva, Switzerland, is really nothing more than less than 165 countries working together as something they choose to call the WTO. It's the member countries themselves. And they've agreed on a framework for lowering barriers to trade, for overseeing trade, and for resolving disputes in trade. It's been in place for 25 years this year as the WTO, and for nearly half a century before that, it was known simply as the GATT, the General Agreement on Tariffs and Trade. The WTO is an institution that's evolved internationally from the original GATT.
What are some of the pros and cons around the World Trade Organization?
Oh, the biggest pro is that it provides a rules framework on which all countries have agreed that makes certain that almost all of world trade occurs almost every day, almost all over the world, consistently with those rules. And thus the flow of trade is secure and predictable. It increases, and that increases overall global wealth and the potential for each country to do more to help its own citizens through the bounties that come from trade. In lowering barriers to trade worldwide since World War II, we've produced billions of annual increases in overall global wealth.
And when we think about some of the cons related to the WTO, is there ever a question about impartiality?
I have never known there to be any question of impartiality in any of the judgments that arise in dispute settlement by the WTO. That's the only case in which there might be a claim of impartiality because of the fact that in all other councils of the WTO, countries are represented by their own ambassadors and delegates. The jurists in WTO dispute settlement are independent and impartial. Just like judges are in tribunals all over the world. No one has ever claimed that they are not, which is, I think, is worth mentioning. The question that has arisen from time to time, as it has, for example, with, say, the Supreme Court of the United States, is whether the judgments are right. But there, I'd say that for the better part, the members of the WTO almost entirely agree that the appellate body of the WTO and the other panels of the WTO have generally gotten things right and ruled in the right ways and at the right times.
So Jim, tell us about the new ruling regarding sovereign states and national security.
Well, there is a national security defense that has always existed in the trade rules, dating back to the aftermath of World War II and the founding of the GATT, that says that what would otherwise be illegal trade restrictions in violation of the rules can be excused if they're taken for reasons of national security. Up until the past couple of years, the members of the WTO have had the good sense not to try to find out what that exception means. So we went for 7 decades without having to know what it meant, and the system worked just fine. Now, with some changes in the view of the United States administration, that particular legal envelope is being pushed. And the question is to what extent different national security claims can excuse what would otherwise be illegal trade actions. Most of these claims are being made against the United States of America because of actions of the Trump administration, but not all of them. There are 2 cases. Last year, a case between Russia and Ukraine, and more recently, a case between Saudi Arabia and Qatar, in which the WTO judges have spelled out the dimensions of how and when and to what extent this exception could be applied. And in both of these cases, they have gone down the road that the Trump administration does not want them to go. The position of the United States of America, since even before the Trump administration, has been that, well, the WTO simply doesn't have any jurisdiction to second guess the sovereign decision of any WTO member on whether their national security is at stake when they impose a trade restriction. The problem with that argument is that Article 21 of the GATT exists, and it lays out the exception, and it sets out when that exception could be applied. And we now have two cases, first the Russia-Ukraine case, and now the Saudi-Qatar case, in which two WTO panels have ruled that the United States is simply wrong, that this exception exists, and when the exception is raised as a defense, WTO jurists are obliged to rule on whether the defense is available. In one case, the Russia case, they said yes, it was available. In this case, new one, the Saudi case, they said no, it's not. So this flies in the face of what the United States has been arguing as a third party in both of these disputes. Mm-hmm. Furthermore, the Saudi case includes some other interesting observations by the panel that would apply to a whole slew of cases that are waiting to be judged against the United States because of the Trump administration's steel and aluminum tariffs. The Saudi panel said there must be a real connection between the national security interest that's being asserted in a particular dispute and the trade restriction that's being applied. In the Saudi case, we were talking about intellectual property right violations in the form of copyright piracy, broadcast rights for movies and sports and television. And the panel there simply could find no connection between the Saudis' assertion of national security defense and whether someone could watch soccer or football or baseball or some soap opera on Saudi television. So they ruled against the Saudis, and the Saudis are now going to have to take some real action against these pirates. Looking ahead, there are, as I said, a whole train of disputes in which countries that have been the victims of the Trump steel and aluminum tariffs have brought suits in the WTO claiming that those tariffs are illegal. The Trump administration in each case has raised a national security defense. This arises domestically from Section 232 of the Trade Expansion Act of 1962. These two rulings seem to me to make it less and less likely that the United States will be able to prevail in these cases when the WTO panels get around to ruling on them, probably early next year at the outset.
Well, Jim, we haven't really had much financial media coverage around that. And in the beginning of the Trump administration's 4 years, that was one of the biggest priorities was trade renegotiation, tariffs, and so forth. I mean, that's really what was moving the markets up until recently with COVID-19. But it sounds like this has implications because, you know, anytime there's a trade headline or a tariff headline, markets would certainly react. And this doesn't sound as if this is necessarily in the United States or the administration's favor.
The legal analysis in these two cases does not help the argument the United States is making. Unquestionably, these steel and aluminum tariffs are illegal on their face under WTO rules. They're tariffs that were taken unilaterally without first going through the WTO dispute settlement system. That in and of itself is a violation of the WTO treaty. The question is whether the Trump administration is excused from these violations because it has asserted a national security defense. The rulings in these two cases, first the Russia-Ukraine case and now the Saudi-Qatar case, strongly suggest that the United States is not going to prevail in asserting those defenses in these half a dozen or so pending WTO disputes. It's its basic argument that the WTO has no business nor any jurisdiction in even ruling in these cases because the United States has asserted a national security defense, has now been thrown out of court, so to speak, by two WTO panels. And I don't see future WTO panels ruling any differently. Now, of course, they will look specifically at these specific measures within the context of the facts of these particular disputes. So the cases will be different. But in my judgment, the United States will not prevail.
Interesting, Jim. Thanks so much for joining us on Trade Talks.
My great pleasure, anytime.
And thanks for joining me. I'm Jill Malandrino, Global Markets Reporter at Nasdaq.